Is posting on Facebook a constitutional right?
This is a fascinating story. It's not about whether Facebook cuts you on or off or not, but it's about whether the government of I forget which state ruled that a sex offender could not go on social media.
Issy Lepowski writing for Wired. Lester Packingham Jr., registered sex offender in 2002, he took to Facebook to celebrate a recently dismissed parking ticket. Praise be to God. Wow. But by using Facebook, he was breaking a 2008 North Carolina law that prohibits registered sex offenders from accessing websites that enable people to exchange information where minors can participate. Facebook is one of those sites. He fought back. He said that's a violation of my First Amendment rights.
Yep.
And it's going to the Supreme Court?
Yep.
Interesting.
Wow.
There was
because
actually
what it says further here is that Facebook, it's not just, it's a First Amendment case, but it's also saying that Facebook is, critical to an open society. It's a speech utility. It's a speech necessity. And I don't know how all that cuts. It's fascinating.
So it's accepted that a state can ban a hacker from using the internet for a period of time. Kevin
but this may challenge that. But it's also.
the state can also. Well, the state can limit where a sex offender lives.
Right. That's what they argue, by the way. It's no.
But the sex offender can live somewhere.
Well,
if this is if this is the primary means of speech.
I don't think you could argue convincingly that it's the primary means of speech yet. But it's worth, and I'm not sure that'll be really an interesting case. You're right, Jeff.
It really is fascinating, yeah. And where's the Times version too? I'm trying to find that.
There was
are they arguing? They've already argued this in front of the Supreme Court.
Oh.
Wait, sounds like.
Is this from 2008? Hold on.
The Times version.
Wait a minute. Yeah, they've.
We're okay.
What the hell? It's in Chinese.
It has a link to the Chinese version.
What? Wait a minute. What? Of the New York Times?
They started doing that, I think, haven't they?
Oh, that's interesting.
All right.
Yeah.
I didn't know that.
I read it in Spanish, so I'm like, okay.
Do you? Wait a minute. Really?
I've started, I'm learning Spanish, and the New York Times has excellent coverage in Spanish. That was Spanish language edition. So I am practicing my Spanish by reading it there.
So this is being argued or has been argued.
Well, no, the justice's remarks suggested they would strike down, says the New York Times, the North Carolina law under the First Amendment.
Right. Justice Kagan took particular issue with the idea that the law would prevent someone from accessing, for instance, President Trump's Twitter feed. This is it's a key communication channel between the president and the public. This has become a crucially important channel of political communication. What?
She said, and I quote, so this has become a crucially important channel of political communication, and a person couldn't go onto those sites and find out what these members of our government are thinking or saying or doing. So Facebook gets to be a right.
Trump saves Twitter.
Because of, yeah.
Now, is he arguing just to be able to get on as opposed to post?
That's right. He could read. There's a question of speech here.
The government or North Carolina argued, well, there's other places they can get information. Samuel Alito agreed. He said, I know there are people who think life is not possible without Twitter and Facebook and these things, and that 2003 was the dark ages.
He's so grumpy.
But I don't know that there are any channels of communications that were available at that time that have been taken away. But the president only tweets on Twitter.
It goes on Facebook too, though, I think, doesn't it? So Justice Kennedy said that social media sites had become, and in some ways had surpassed, the public square as a place for discussion and debate.
Right on, right on, right on.
Quote, the sites that Justice Kagan has described and their utility and the extent of their coverage are greater than the communication you could have ever had, even in the paradigm of public square, Justice Kennedy said. Wow.
So maybe you just need to change your sentencing laws, because in jail you don't actually have access to these places, to social media sites necessarily. So then that kind of raises the question of, could you institute a punishment for someone like a sexual offender that actually sentences them to not having access to this over a period of time, which is kind of that would be a way around this. Yes.
Well, we'll find out this summer when the
so they
ruling
also
comes out. Wow.
They mentioned LinkedIn, and they say that if this complainant wanted to try to find a job, the way you do that is on LinkedIn, and teenagers are allowed to post information there. Ergo, you've cut them off from being able to get a job.
Isn't that fascinating?
Justice Kennedy mused that any number of free speech doctrines doomed the law.
Interesting.
Really fascinating.
Where do you stand on that? Should Facebook be a fundamental right that can't be?
Well, and then, here's the problem.
We don't let felons vote. I mean, there is precedent for governments.
There's a lot of people who think that is crazy wrong and want to change that, though.
But there's plenty of precedent for a government restricting somebody's rights based on a criminal conviction.
That's not covered by the First Amendment. The First Amendment is a matter of speech.
So you think that the right to speak trumps the right to vote?
It clearly does. I mean, the Constitution,
Yes.
that's franchise versus speech is